Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
all right.
I made. And then when I amended it.
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was.
Thank you.
Sort of elaborate on it, or yes, I guess you could say it was fixed.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
okay.
Yes, I was not saying that. I was saying.
Good to know.
My apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday.
Yesterday. Okay. Yes, well, that may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop. Yes. Okay. It's in front of me now, so.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control. My apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is,
okay.
Yes.
Okay. So as long as we're all on the same page with that, and I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
yes,
where the court actually says, hey, you know what, these can be tricky, these can be dicey. Here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure the court's exposition of that issue in the Waddell case.
And in that amendment, I did correct the Waddell site.
Okay. All right. So we'll follow that law as well.
So, Your Honor,
yeah. And so I guess I don't know if you've got specifics with regard to things that you believe have not been turned over or that exist and haven't been turned over.
Well,
okay.
I cite, for example, in these amendment to the supplement on page 1, the first example was recordings that were held by counsel for defendant Williams of an interview conducted with state's witness Adrian Bean. The evidence that was shown at trial was that Mr. Bean was a co-conspirator with defendant Williams in an intrinsic armed robbery. The state conducted